Welcome back to our series of intellectual property lectures. We're moving into part 8 now, where we're talking about trademark infringement. So what happens when someone uses your trademark or you use someone else's? What liability might you face? But first, let me introduce myself. My name is Jeff Keiser, and I'm a practicing lawyer from the United States that's worked on cases in many fields of law, big, small, and otherwise. I love the law. I love practicing law. I love working with people. Most of all, though, I love working in my role as a legal English educator. I've taught hundreds of people around the world, and I hope to continue doing so in the future. But first, but second, I should say, trademark infringement. If someone owns a trademark, that party can sue anyone that uses it without permission. The standard here from American jurisprudence and statutes is a likelihood of confusion. Now, what does that mean? That means that the trademark that's infringing upon your trademark needs to cause some kind of consumer confusion as to the source of those goods. We don't want a second company selling products to people that think that they're buying it from your company. It's that simple. So we don't want to confuse the marketplace. We'll talk about that a little bit more in just a bit. But how we factor out what is confusing, the courts look at 7 factors. This is one of those balancing tests of the law, where we have to look at all of the factors and assess them on an individual basis. We have to look at the strength of the mark. Is it Coca-Cola that has been on the market for 100 years? Or is it something that was just trademarked yesterday? We have to consider the proximity of the goods. How close are they to one another? An example of this is Apple Computers does not infringe on the trademark of Apple Records, who own the Beatles catalog. We also have to look at the similarity of the marks. Are they the same size and shape and color? We can show evidence of actual confusion. Maybe we call consumers as witnesses or get affidavits, and they would say, I was completely confused. We look at the similarity of the marketing channels used, the degree of caution exercised by the typical purchaser, and finally, the defendant or the infringer's intent. If they come out and they say, yeah, we were trying to copy this other product, well, there's likely trouble ahead. Like I mentioned, I'm using Apple Computers a lot in my examples. I hope that's okay with everybody. But if we use the exact same mark selling the exact same product, that is the easiest case of trademark infringement I have ever heard of. If I, in my basement, manufacture and sell computers under the brand name Apple, it could confuse the marketplace. If I bought an Apple computer, I would certainly be expecting it to work like a MacBook, at the very least. Now, using a very similar mark could also be infringement. Let's say that I don't open Apple computers in my basement, but I start selling an applet computer. That's probably too close for comfort, and since I imagine Apple's legal department is very good, I wouldn't want to run that risk. You'd also run into problems if you used another fruit. Let's say you make pear computers or apricot computers. It's going to depend on those other factors, I suppose, because it's the same product. That's really the issue. Like I said earlier, Apple Computers will not infringe on Apple records. They can peacefully coexist because buying CD or a streaming service, or however music is bought today, is not the same as buying a computer. It's a completely different product. So infringement is relatively easy. All we want to do is look at whether there's confusion in the marketplace. It's a balancing test, and it's really fun to argue these back and forth. But in addition to an infringement claim, a trademark owner can also bring an action for trademark dilution. Now, this is only available if the trademark is quote-unquote famous. What is famous? That's a whole different subject that we don't need to talk about today. But this will be a big name brand. Think Nike, think Apple Computer. It's a famous mark. And to determine whether it's famous, you're looking at the degree of inherent or acquired distinctiveness, the duration and the extent of use, the amount of advertising and publicity, the geographic extent of the market, the channels of trade, the degree of recognition, any use of similar marks by third parties, and whether that mark is registered. Apple is a good one. Kodak, Exxon, Xerox. These are all examples of famous marks. People know what they are. And dilution is really making it's not killing the value of your mark, but it's lowering the value of that mark. Damages in trademark are interesting. The easy one to understand is that a court can make a defendant stop using the infringing trademark. That's easy. And an injunction like that is the easy thing to seek. But monetary damages may also be available. And if you can show bad faith, you can even get treble damages, meaning triple damages. Bad faith is often very difficult to prove, but it's one of those things that if you have a really great defendant that has very bad faith, you can get 3 times the damages that you can actually prove. All right, guys, that's going to wrap up our discussion on trademarks, and we're going to move into copyrights. Copyrights are great fun, and I think that it's the best part of intellectual property law. That's why I saved it for last. See you in a few minutes, and I hope you have a great day. Bye-bye.